Thank you, Mr. Chairman. I want to thank all the witnesses for being here and for their patience. We have heard a lot of words today. I marked these, Ms. Wad, when you said them the first time through. I think perhaps the most important words we've heard today were in your prepared testimony. You said, "I'm here to provide a sense of urgency regarding the need for streamlined regulatory and administrative rules." And then you said, "Large, powerful firms can afford armies of lawyers and attorneys to stay compliant. Smaller entities do their best and try not to slip up." Mr. Chairman, that is what this hearing is about, and I want to thank you for calling this today. Look, this stuff can get mind-numbingly dull, especially when you get into the academic literature surrounding administrative law. But there's a fairly new book out. It's in plain English. It's not aimed at an academic audience. I don't know if our witnesses have had a chance yet to read Justice Gorsuch's new book, Overruled: The Human Toll of Too Much Law. I see Mr. Vladeck has a chuckle. Apparently he thinks the justice is insufficiently brilliant on this subject matter. I have a different point of view. One of the things that appears in that book is a chart drawn from the Regulatory Studies Center at George Washington University. I've asked the staff to place it on the screens for us. This is a chart of the number of pages in the Federal Register starting in 1950. Take a look at that chart. It's a zero-based chart. It's not cutting off the top. It's about 10,000 pages of regulatory law in the United States in 1950. The year I was born, 1968, it had exploded after the Great Society to about 50,000 pages. It is today pushing 200,000 pages of binding regulatory law. Mr. Chairman, that is why the folks I represent in Kansas sound a whole lot more like Ms. Wad and Mr. Smith than they do like Professor Vladeck or some of my colleagues on this committee. They're not worried about the academic impact and the theory. They're worried about what it means for their day-to-day lives, and can they stay compliant, and can they continue to operate, and can they pursue the American dream? So I have a couple of questions for our witnesses. Let me start with Mr. Smith. Mr. Smith, as Kansas Attorney General, I took a number of cases all the way to the U.S. Supreme Court challenging various federal regulatory actions. I know how burdensome it can be. I'm thinking of one when we challenged an Obama-era iteration of the Waters of the U.S. rule. We started in district court in Georgia. We ended up MDL, and I think it was Ohio, fighting about whether we'd started in the right court. We had to await a U.S. Supreme Court decision on the jurisdiction issue. We went back to Georgia after that all happened. We finally got an injunction, and the administration appealed, and then we were 3 presidents later before the political system finally overtook the litigation. You talked about how much money you spent fighting your one battle. Could you have used that money more effectively in some other manner?
Oh, goodness, yes. I mean, we could have put it into research and development, building new products, innovating, entering new markets with sales investments, lots of places that would have had a return for our investors.
Did the regulators pay your attorney's fees when that was all over?
No, sir, they did not.
I see. And Dr. McLaughlin, let me ask you this. I was intrigued by my colleague, Congressman Iss's line of questioning. I was especially intrigued when he went down the panel, and I believe all 4 of our witnesses agreed, Professor Vladeck enthusiastically, if I'm not mistaken. I don't want to mischaracterize it, but as long as there's bicameralism and presentment, I think your words were you would like to see Congress do more of overseeing and deciding whether to keep particular regulations. So my question for you, Dr. McLaughlin, is this. The Congressional Review Act currently has what is functionally a fixed look-back window. Right now, I think if it's a regulation came in around August of last year or later, we can use the CRA's mechanisms to decide whether we want to keep it or reject it as an elected body exercising the Article I power that is ultimately the basis for the regulatory action in the first place. Is there any reason we ought to limit ourselves to this functionally 6-ish month look back? We got a bill on the floor this week that would make it a year look back. Would that be better?
There's no reason not to extend the look back, in my opinion. Extending the CRA would allow more. We're talking about midnight regulations effectively that the CRA.
But we don't have to be, right? I mean, why are we worried only about midnight? I think it's great to be worried about midnight, but why not 6 p.m.? Why aren't we worried about a regulation that was promulgated in 1994 if it no longer makes sense? And you have bicameralism and presentment, and this body wants to reject that regulation, or in 1958, or in 1973. What's the rationale?
I don't think there is a rationale for not extending it further back. I think that we're just stuck in a situation of inertia.
We've always done it this way. Would you encourage us to take a look at amending the Congressional Review Act to give this body the authority under its procedures to reject agency regulations regardless of when they were promulgated?
Well, as a scholar, I'm hesitant to endorse any specific bill, but it
Just
does
asking for
seem
the
like it would have
concept.
positive economic consequences.
Thank you very much, Mr. Chairman. Thank you.